Good afternoon, and welcome to Life Experiences with William Pelarenos. I am here at the WRMN 1410 radio studio in lovely downtown Elgin. And my guest today, I'm really privileged to have this man here. He's an attorney and a former prosecutor, Edward Olivieri. Edward, thank you for coming to the show.
Thanks so much, Bill, for having me. I really appreciate the opportunity.
Edward, I asked him to come on today because a few months ago I happened to mention about wills and trusts, and we got a few questions in. I had taken a class on wills and trusts. Eddie wasn't teaching it, but the teacher that was teaching it couldn't come on. So I happened to be on Facebook, on LinkedIn, and I happened to see Eddie. His practice now is focused on trusts and wills. So I asked him to come on, and he agreed. Our phone lines are open if you have any questions. What's our number, Matthew?
It's 847-931-1410.
And we're also transmitting on YouTube, I see?
Yes, youtube.com at WRMN Radio.
And they can text us.
505-926-1410.
So get your questions or comments here. We're here live. Eddie is doing us a big favor by coming. He had to change his schedule around and come in here today. I appreciate it. Just giving you a little bio. Back in 2008, you were my prosecutor at Bridgeview?
That's right. That was when I was in the state's attorney's office, and you were still with the sheriff's police.
Yes, and then after a few years, you went into private practice working for law firms, correct?
That's right, yeah. So when I left the state's attorney's office in 2008, and I went to a law firm called Reyes Bonoma, which at the time specializes in government affairs, and I did a lot of administrative hearing work, and then I built a criminal defense practice. From there, I left and started my own firm with a partner, Mario Godoy, who still operates that firm. We did criminal defense, immigration, and a lot of small business advisory work.
That's great. And now your practice is focused on trusts, living trusts, wills, and so on, correct?
That's right.
Estate planning is the term.
That's right. So a number of years ago, my father was diagnosed with Alzheimer's disease. And I didn't really, at the time, I wasn't really familiar with estate planning. I was mostly a trial lawyer. And so I wasn't able to help them. Thankfully enough, one of my former colleagues in the state's attorney's office did that type of work and was able to help out my family. But I realized that was a skill set that I needed to develop. And so I put my time in to learn this area of practice. And this year, I finally launched Fireside Planning, LLC, which is my law practice. And we specialize on estate and legacy planning on one side, and then small business advisory work on the other side.
That's excellent. So you're really trying to help out people, make sure all the bases are covered. Well, we're all going to have our demise when the time comes.
Right.
You want to, what's this, the term, division of property, correct?
Well, that's right. So estate planning handles a number of different issues that come up for us, right? So one is, how is our property distributed, or not just property too, it also is our legacy, right? Our values, our stories. How do we pass those on to the next generation? How do we protect our assets from liability? And also to minimize taxes. And then the other piece of estate planning is, how do we make sure that we are protected if we are disabled? And so we create documents in order to name people so that you, as the client, you get to decide who gets your assets, what assets you give to people, and who's going to take care of you and make decisions for you if you're unavailable or you're unable to do so.
You know, you make a good point there. Let's go on that disability for a second. I, as a policeman, 27 years, handled a lot of traffic accidents. And there was cases where the person did not die, but they were so severely injured. They're in a coma. They can't communicate. Part of this living trust or estate planning, you designate somebody that can get access to your medical records that can help the medical staff make a decision, correct?
That's absolutely right. So we create healthcare powers of attorney, where you name the person that you want to make decisions for you if you can't. And so that handles that situation. The other thing is a HIPAA directive, so they have access to your medical records. Because if you're over 18, you're not going to have the ability to do that without a power of attorney. This is particularly important for people with students in college. because they're adults, right? We may think of them as kids because they're our children, but they're over the age of 18. And so, God forbid, we have a college student get injured or an adult child who's out of the country or out of state, and there's an issue, you need someone to be able to make those decisions. And if you don't have that power of attorney, then you have to go to a court to get those authorities, and that takes a long time and it's very expensive.
You make a good point there. It doesn't happen to everybody, but it does happen to people, and they fall into a legal rabbit hole without the proper documentation. So an example would be I would designate my daughter to have access to my medical records in case I'm incapacitated. And in return, on that same document or same package, she can designate me, even though she's an adult, she can designate me to make those same decisions and access her medical records. Am I correct?
Absolutely. Yeah, and so those could be reciprocal, right? We create separate documents, but ultimately the authority would be designated. And that way right? Because when something bad happens, we can't predict it. And so having those documents in place so that people are protected, yourself, your information, your assets, and ultimately your agency, right? Your ability to make those decisions instead of a court making those decisions that doesn't know you, that doesn't know your values, that doesn't know anything really about you. This way, you're taking the power into your own hands.
This is a great asset because people don't think about this. But you got to understand, folks, I handle a lot of traffic accidents. In the United States, 30,000 Americans are killed in traffic accidents. Just traffic accidents. I mean, we hear about the plane crashes, but those are rare. Mm-hmm. It's traffic accidents. People are meet their demise in, unfortunately. So you got to have, to me, dot your I's and cross your T's in legal documents. Mm-hmm. A lot of people think a will is good enough, but it's been brought to me, especially recently, that if you have property, you really got to go with estate planning. Do you agree with this?
100%. So a will is a direction to the court as to how you want your assets to be distributed, right? And so when I say it's a direction to the court, what that implies is that you have to have a probate proceeding. And so if a person dies with no documents, meaning intestate, the state of Illinois has a standard way of operating. If you die only with a will, you still have to go to probate court, and a judge has to make those determinations using your will, and it can be challenged. And those wills are also public documents. So you file that in court, and those wills are available for the world to look at. Whereas when we do a trust-based plan, we put your assets into a trust, and that's a private document that the world doesn't get to see. And the ownership transfers immediately upon death. There's no need to go to court. And probate proceedings take a very long time, easily a year or more, and it can consume easily $10,000 in legal fees. And so a lot of people think that a trust is only for people who are really wealthy, and that's not the case at all. I would recommend a trust-based plan to most clients, but particularly anyone who has any property.
You make a good point here, because I know of a case recently where a man passed away, and his two sons, when it went to probate court, they started battling over the house, just the house. That was the only property that was left. His assets already been used by him. But over a $350,000 house, they were going month after month with lawyers until the judge made a decision, and it got ugly. And you really want to avoid that for your heirs, correct?
Oh, 100%, 100%. Estate planning does more than just those legal protections. It also protects your family from those often inevitable conflicts over property. The other thing is that while those cases are being litigated, the property can become damaged, property may not be maintained, additional expenses are levied, maybe you get tickets from your municipality because the grass isn't cut, things of that sort. And so dying without a proper estate plan can be a very, very expensive proposition and a very contentious proposition for your heirs and for your family members.
Because they would end up paying some sort of taxes, right?
Well, there could be a tax issue as well, no question about it. But Primarily, the issue is you're going to have to go to court on a regular basis, and that's fees and that's time. And then also, you're going to have to maintain that property. If you're fighting about it, it's not going to be maintained, which means that then properties decline, right? The roof gets a leak, it's not being fixed. Basement floods, not being fixed. Grass, you can start getting all kinds of other issues that add additional expenses. And so now, instead of your house in this situation going directly to your descendants, now there's going to be a whole bunch of animus created, conflict created, and expenses along the way. And they're not going to end up with the legacy that you really hoped for.
Yes. So what you're designating is the division of your property, your medical powers of, should I say the term medical powers of attorney? Is that correct?
Yeah, that's right. That's right. So a healthcare power of attorney. When we do an estate plan, the primary documents are going to be, it's called a revocable living trust, which is going to hold your assets. A pour-over will, which is going to address any property that you acquire or you dispose of outside of the trust. So say, for example, you set up your estate plan today, and 3 years from now, you buy another building, but you don't transfer it into the trust. Well, that property is not going to be protected under the trust, and so you're going to have to go to probate for that, and that's where the pour-over will comes into play. So even though we want to avoid probate at all costs, if you have to go to probate, you want to make sure that you have a will there in place so that the court has an understanding of what your wishes really are. And then the other piece that's very important on the will side is nomination of guardians if you have minor children, which is a very, very critical component. More on that in a moment. So we said we have the pour-over will and we have the living trust. Then we have a healthcare power of attorney. So that's a authority that you're designating to the person or persons that you decide who are going to make healthcare decisions on your behalf if you're unable to. You're going to have a similar power of attorney for property, someone who can make decisions for you on your financial assets. So they can pay your bills, they can have access to your bank accounts, they can pay your taxes and deal with the IRS or the Illinois Department of Revenue if you're in Illinois. Those are the documents that you want to have. And then, of course, a HIPAA authorization so that those people that you want making your medical decisions for you have access to your medical records that are protected under the HIPAA Act.
You know, you make a good point. I forgot to mention this. We were talking about earlier about not only we're talking about adult children, but children under 18. There have been cases where the parents, there was at least one case where the parents left the kids with a babysitter. They went out someplace and they were killed in a fatal car accident. Now here's this babysitter sitting with two kids. The parents ain't coming back to get these kids. There has to be some kind of designation for some immediate action, correct?
That's absolutely right. And so what I always recommend to clients of mine that have minor children is we create what we call a kids protection program. And what that essentially is that in that pour-over will, we nominate guardians, and that's long-term guardians. Who do we want to take care of our children long-term? But in the immediate aftermath of a tragedy like you just described, Bill, that babysitter isn't going to know what to do. And maybe that babysitter isn't even an adult. Maybe that's a teenager that's watching your kids. What is that person going to do? Well, they'll likely call the police, and the police are going to have to bring them, and DCFS is going to have to take custody of those kids and place them with someone while the pendency of that probate action is litigated, and that takes time. And no one wants their kids to go into DCFS custody if you can avoid it. And so what we do there is we do a nomination of short-term guardians, which is for a year. So now immediately those kids go with the short-term guardians, and they're there and they're safe and they're protected while the long-term guardianship is decided by the court. But you know that you have 1 full year where that short-term guardian is in place. Oftentimes they're going to be the same as the long-term guardian, but the idea is immediately in the aftermath of that tragedy, those children are going with the people that you want to take care of those children. And in that plan, you can also privately designate people that you don't want to take care of your children. You can also split it up. It doesn't have to be to, your brother and sister-in-law. Maybe it's one brother-in-law and the sister-in-law if they're married, What if they're not married? Well, you can address that. So all of those contingencies can be planned for if we start to engage in the process and do the planning properly from the very, very beginning.
I'm glad you mentioned people that you don't want around your children, because sad to say, folks, every family's got a black sheep. Some have two. But that's very important, because you want to keep our children, and this is the greatest saying I've ever heard, our children are our most precious commodity. Mm-hmm. We raise our children. We've given birth to them. We've raised them. We feed them. We house them. We try to educate them, and we try to put them on the right path. You don't want somebody that's on the wrong path influencing these kids or taking control over them, because DCFS, which is the Department of Children and Family Services, always tries to place the children with a relative, but they might be putting the wrong relative in charge of these children. What do you think?
That's absolutely right. And DCFS is not in a position to know what you want. And so they're going to do the best they can. But the best they can is not necessarily what it is that you want. And so making sure that you have this laid out in writing in a properly executed document is absolutely critical, because then they're going to follow your wishes, and the people that are taking care of your kids are going to be the ones that you choose, and not someone who doesn't know you or your children or your values.
Yes, and not only are children our most precious commodity, we work too hard for our property, our assets, your home. And people always think about their home, but there's also other assets. Bank accounts, correct?
That's right. Bank accounts, retirement accounts.
Yes.
401ks, pension plans, life insurance. So people have all kinds of different investments or other assets that they have purchased for the benefit of their heirs. And so we want to make sure that we properly allocate those assets, either in a trust or through beneficiary designations, so that they get to the people that you want them to get to. And then also we minimize estate taxes. So in Illinois, estate tax begins at estates at $4 million. At the federal level, it's at $14 million. And so when we get estates that are starting to get close to that $4 million mark, that's when we have to be very, very careful about making sure that we're planning appropriately to take advantage of every tax benefit possible and to minimize the taxes of the estate.
Yes, but even if you don't have that, even if you haven't reached that parameter, the $4 million, houses are worth $250,000. Sure. You've got some life insurance or some kind of burial insurance that's sometimes $50,000, $100,000. You got bank accounts with money in there. All this has to be designated where you want to go. And, people don't want to think about their demise, but it's going to happen to everybody eventually. Unfortunately, it happens to some people sooner than expected because of accidents.
That's fact. And it's going to happen to all of us. And most of us don't want to spend much time thinking about these things. And so when I decided to open this practice, I chose to model my practice on a very high touch, not scalable, but very, very high touch practice. And so I meet my clients where they're most comfortable, which often is in their own home. And the reason why is because we're going to be talking about challenging things that can be very, very difficult to discuss, and decisions that most of us don't want to think about all that often. And so what I don't do is want people to come to a scary, cold, weird law office to have this conversation. I like to talk to people, across their kitchen table and try to plan something that is going to be very unique to them. So an estate planning lawyer and a client, it's a very intimate relationship, because I want to know your values. I want to know about your family. I need to know about all those different components that inform how you want to plan and how you want to think about, what legacy you want to leave behind, because none of us know when that day is going to come, but it's going to come for all of us. And so I think it's best to provide an environment that is safe and that is comfortable, and that people feel that they can actually express themselves from the heart. My wife is a psychotherapist, and I often refer people to her, to other therapists, because oftentimes we need some help to really understand what it is that our goals are and what it is that our fears are, so that we can do the legal planning appropriate to that individual.
Well, we got a couple minutes left before our news break. Matt, bring up his website so people can connect up that are on YouTube. What's the website?
Yeah, it's firesideplanning.com.
Firesideplanning.com. So let's see what he's got. Is that your website?
That's the website, yes.
All right. So you have About Us, you got your services, and you got contact information. Let's go to services.
That's right.
Our services. I can't read that, Eddie. Tell me what this says.
Yeah, so it says that together we're going to structure a plan that ensures that you're making the decision. So fundamentally, the whole idea is I want my clients to be empowered so that they make the decisions about who's going to do the work in the event that they're unable to. So who's going to make my financial and healthcare related decisions? Who's going to take care of my kids? And how are those assets going to be allocated for future generations? And so we create a trust, we create the appropriate powers of attorney. All of those documents go into your estate plan, and they're always individually based, right? So generally speaking, a trust-based plan is the way to go. But there are some folks who don't really have any property, and so a will-based plan works for them. But it's always an individual decision.
All right, we'll get to the documents in the second half of the program. We're going to go to a quick commercial break. Eddie from, what's the website, Fireside?
Fireside Planning.
Firesideplanning.com. So if you're not following us on YouTube, you know where to go. We're going to come back. Phone lines are open. Matthew at what?
847-931-1410.
Okay, stay with us. We're going to be back right after the break. This is William Pelarenos on Life Experiences. And I'm glad to have you. Thank you, Eddie. But stick around. We got another 24 minutes to go as soon as the break. Stay with us, folks. Don't change channels. Welcome back. Welcome back. This is the second half of Life Experiences with William Pelarenos. And today, my guest is attorney Edward Olivieri from firesideplanning.com. Did I get that right?
You did. That's right.
Okay. And if you're just joining us, what we're talking about is Eddie's practice that focuses on estate planning. And estate planning is not just a will, but it encompasses certain other documents, living trust, all your real estate, division of property. We were talking about medical powers of attorney in case somebody like myself, I'm incapacitated, say in a traffic accident, I can't make a decision, I'm in a coma. I need somebody to access, and we use the term HIPAA. And what the HIPAA is, the Health Insurance Portability and Accountability Act. Eddie, can you give our listeners a quick brief on that?
Sure. So HIPAA is a federal law that does two things. One is that it protects our healthcare information from general distribution, right? So the idea is that we keep our healthcare information private. And it also facilitates moving that healthcare information between different providers, right? So if you have one doctor that you're going to for one thing and a specialist for something else, HIPAA allows the transfer of those information, of your healthcare information from one provider to another. But in most people's situation, when we're talking about HIPAA, we're referring to the privacy protections that HIPAA have over our health information. And why it's important in estate planning is that if an individual is incapacitated, they're not able to request their own healthcare information because they're incapacitated, and then other people similarly can't have access to it. And so that's why we want to plan for that. So in the case of someone being disabled or incapacitated, that the person that they designate, that they choose, gets to have that access to that information so that they can help and support the care that is required by the disabled or incapacitated person.
See, many years I've had a will, and I designated my heirs, of course, for my house, my property. But up until this year, this is when I started to get into the estate planning. I started going to a couple of classes, and I reached out towards you, and we had the listeners calling questions. And I can't answer the question. I'm an attorney. We need an attorney. So this man is here. Our phone lines are open. If you get a question, what is it, Matthew?
847-931-1410. We got a caller.
We got a caller already. Welcome to the show.
Yes, I spoke to you the other day. You said to call in today. question is, how does one handle the transfer of firearms when one dies?
It's a really, really fantastic question. So I had a situation like this when I was a criminal defense attorney, where I had a client who inherited a gun but didn't have a FOID, didn't have any interest in it, and didn't really know how to handle it. And so how we plan for that is we create something called a gun trust. And so a gun trust has a number of different benefits, right? First, it facilitates the transfer of title. The other thing is that it gives people access. So it's commonly used. Think of the situation in which you have a family where you have maybe 2 or 3 generations and they like to hunt together. The person who owns the firearms can put those firearms into a gun trust and then designate other co-trustees, and all of those co-trustees will have access to the guns in their lifetime, right? So they won't have any issues of, I'm holding the gun, but it really is grandpa's gun and I'm not supposed to have it. We address all that issue to the gun trust. And then we also designate that those co-trustees will be the beneficiaries, meaning that they're going to get title to the guns upon the death of the person who's setting up that trust, also called the grantor. So that's a great way of handling it. You can also do it through a standard revocable living trust, but gun trusts are particularly helpful because it keeps people in who have their firearm owner's identification card and have the guns properly registered, and so that it's a seamless transition. So that's a really, really great question.
Okay, my question is, at this point, I have a trust. I'm going to be dealing with an attorney. I already have an appointment to make out a will in addition. But in the trust, I have at least 3 individuals that are currently firearm owners, ID card owners. Mm-hmm. And so if I merely mention in the will that the firearms, because I have a number of them, will be distributed to those that have the necessary requirements by the trustee who handles distributions.
That's right. That's exactly how you should handle it. Is in the context of your estate plan, having a trust is very important. A will is also very important in case you acquire property that after you set up your estate plan, if you don't update your estate plan. It's common that people don't. They create an estate plan and never look at it again, but may buy a property, may buy a gun, may sell a gun, may sell a property. So that's why normal, regular, routine reviews of estate plan are really important. I'm glad that you're talking to an attorney about this, because it's very important to do that, particularly with firearms, because not everyone can own a firearm. And so you can leave in a will anything to anyone, but that doesn't mean that person can legally take title to it. And so it's good that you're planning for that and that you've identified people to give them to who are properly licensed to have those guns.
Thank you very kindly.
You're very welcome.
Hey, listen, this is one of the callers that called in with the questions when I announced your appearance here last week. And I said, hey, next week, you got to call him and ask him. That was one of the questions that came out. Yeah. But thank you for calling us back with it, because this is the man to answer your question. This is the guy who went to 3 years of law school. He's got so many years of being an attorney, and this is his focus now. Yeah. I couldn't answer that question. I'm the expert, has to bring on the experts.
That's fantastic. Happy to be here to do that. And it's particularly important for police officers. Both of my parents were Chicago police officers, and of course, they own firearms. And so planning for that is really, really important. My brothers have FOIDs, I don't. And so I am not the one to inherit. And so it's very important to create that plan so that the appropriate people get the appropriate items.
So that's also a key element. They have to be a FOID owner or holder in Illinois. But what if you want to designate guns to somebody like in Wisconsin, there is no FOIDs? Then that's not a problem, correct?
That's correct. That's correct. They're going to have to comply with the laws of their state. But the idea is that you should identify that they're complying with the laws of their state at the time. And then we can always help fill out paperwork if you have to go to ATF or other federal agencies. Certain firearms require a higher level of scrutiny in order to be able to own them and operate them. And some people have some pretty significant weapons, and so any type of weapon like that, we're definitely going to recommend a gun trust. If it's a regular firearm, then just a revocable living trust is fine to do that. We just want to make sure that that's listed on a memorandum of personal property, which you would do with specific items, right? If you have a wedding ring that you want to leave to a specific person, or a car to a specific person, same thing with a firearm. We just want to make sure that the person that you've designated is a person who actually can take title to that firearm.
Thank you again. I know in some states, when somebody who has registered firearms, when somebody passes on, if there's no stipulation anywhere, they just come around, pick them up. That's it.
Yep, that happens. That happens routinely, and sometimes it's okay, but not always. And so it's very important when you're dealing with firearms or anything that's highly regulated. It's very important to seek counsel that has expertise in that area.
While I got you on the line, I got to tell you a horror story. A friend of mine was a policeman. He retired. He worked a part-time police job. He started a will, had it written out, never signed it. It was on he was single, never married. He never signed it. The will was on his desk or something. And on Thursday nights, he used to get pizza delivered. Well, what happens is going down the stairs. I can't remember if he had a stroke and he fell down the stairs or he broke his neck from a result of the accident, but he's dead at the bottom of the stairs. The pizza man finds him. Tragedy, of course. But that will was never signed, so it means nothing, correct?
That's right. That's right.
You have to sign your documents, you have to date them, but you don't have to notarize a will, correct?
Not a will. No, the powers of attorney do, but wills don't have to be notarized. They have to be witnessed, but they don't have to be notarized.
So the wills have to be witnessed, but he did not have this estate planning. And I don't know what branch or Cook County government came in, but they came in, they took his guns. They even went to his storage lockers and took out his guns. He had a lot of guns, over 30 years of policeman. He's one of these gun collectors. He used to buy one gun to shoot in the same model to save as like a collector's item.
Wow.
This is what he did with his money. Sure. A lot of people go out drinking, partying, vacations. He never went on that. He worked 2 jobs, and he was a gun collector. And he lost all that. The Cook County government, and I can't remember what branch took it, but they came in and they took his stuff.
Yeah. So when folks die, it's called intestate, which means they have no documentation. The court, and if there's no one, if there are no real heirs, the court will appoint the Cook County Public Guardian. So the Public Guardian's office, they represent minor children in abuse and neglect cases, and then they represent intestate folks that don't have any heirs, and they manage the estate. And often there's a significant amount of money in there, and that ultimately all of that money will go to the state of Illinois. It's called escheatment. And so you lose all that. And so for folks who've built up a legacy like this individual who had a substantial gun collection, that can't be cheap. I know it's going to be very valuable. To lose all of that is pretty devastating. And so that's why estate planning is absolutely critical.
Are we there?
I'm here.
Okay. I got one more. All right, well, I got you in the line. Thank you for calling. I got one more question for the attorney. When we put our heirs, it doesn't have to be relatives. We can designate property to anybody we want. Friends, charities, correct?
That's right. That's right. And you can also designate other trusts. So, for example, folks who have like a special needs child, you can create a special kind of trust for special needs kids. I'm going to say kids, even though you can do it when they're adults. And those trusts protect that individual's assets from being reviewed for any means-tested benefits. So that's a mouthful. What that means is that long-term care for most special needs people is going to be so expensive that most people cannot afford to save enough money to do it. And so most special needs folks are going to end up relying on Medicaid, which is means tested program, which is a health insurance program in the United States that is funded by the federal government but administered by the states for poor people. In order to qualify for Medicaid, you can't have more than $2,000 in assets. So if you don't do a special needs trust, what happens is that whatever you leave, that has to all get spent first. And once all of that is spent, then they can qualify for Medicaid, which takes time. By creating a special needs trust, the assets put in there are for the benefit of that special needs person, but that doesn't count towards their $2,000 maximum. And so that's a way of taking care of those special needs beneficiaries over time, so they still qualify for Medicaid, but they can also have additional assets to provide, extra pajamas or schooling or classes or
computers, iPhones,
whatever it is, so that they get to have some extra. And so in your trust, you can designate, if you have, say, for example, you have a relative who has special needs, we can set up a special needs trust for them, and you can fund with a portion of your estate that special needs trust. So that way you can have multiple family members trying to support their special needs family member. So it's not only on the parents to be able to take care of them, but aunts, uncles, cousins, friends, anyone can designate an amount of money to go to special needs trust.
Are we clear? Did we lose our caller?
Are you still on? Okay.
No.
Yeah, I think we lost him. But I think you basically answered the questions. And I like the fact that you brought the special needs, because a lot of people have children that have special needs. Right. One of my friends, he had an autistic child. He was raising him. But what happens when he gets in an accident or something? Right. It has to be all, you have to dot the I's and cross the T's, as my sergeant used to say.
It's absolutely true. Critically important.
And in my current will, and I'm going to do this estate planning in a few months, I'm going to do this whole thing, which includes what? The living trust?
Yeah, so the primary documents in an estate plan, I mean, there are many depending on people's circumstances, but the primary ones are going to be your revocable living trust, your we call it pour-over will, your healthcare power of attorney, your power of attorney for property, and then your HIPAA designation. Those are going to be your primary ones. If you have minor children, you're also going to add into your will, you're going to put in a nomination of guardian, meaning who do I want to take care of my kids if I die? We also want to add in a short-term guardian appointment so that in the event of that tragedy we talked about earlier on, where both parents are killed while the children are home with the babysitter, so that someone can immediately take custody of the children and have guardianship over them immediately, while the guardianship in the will goes through the probate process. So essentially it becomes seamless. And then we can add other things, right? Like gun trusts and special needs trusts. So we can get it can get as creative and complicated as you can imagine, or it could be relatively straightforward, right? So people who own real estate, for example, we're going to add other, multiple real, like investment properties. We're going to add all their layers into the mix as well, so that those assets are protected as well.
You made a good point earlier, and there's so much aspects to this. It's best to get a consultation with an attorney like Eddie Olivieri here, because you can write down what you need, what you don't need. What I didn't think about earlier that you mentioned, I always think about real estate, your house, but you mentioned a good point, jewelry. People don't think about the jewelry. Some people spend a lot of money on jewelry, and if you don't put it in the will, it's got to be in there, correct?
That's right. You can be handled multiple ways, but particularly when you have some valuable pieces of jewelry, and also if you have specific pieces that you want to leave to specific people, we want to address that in the trust. And so we can do that in a number of different ways, but most commonly we use a memorandum, a personal property memorandum that lists out those specific items that you want to leave to specific people. Because if you just leave the assets in a trust, and you say you have two children, you're dividing your assets 50-50, well, maybe there's a particular necklace that's more valuable than ring, or vice versa, and one wants one and one wants the other, there's an opportunity there to create some conflict. And so addressing those specific personal property items is very, very important.
Yes, thank you for bringing that up. And it's most important that if you're going to go into the estate planning, think of all your valuables, your bank accounts, your life insurance, your, I don't want to say death insurance, but people have burial insurance where they can buy $25,000, $50,000 policy to cover their final expenses.
That's right.
And your jewelry, if you got any valuables, like I have some valuable movie posters. I spent a lot of money for them. People got valuable books. People are book collectors. You put it all in there, you make a list, you meet with the attorney, and when people would meet with you, you don't charge an initial fee to consult with them, do you?
No, that's right, and that's a really good important issue that you brought up, Bill. I don't. So if you're considering engaging with me, what we do is we start with a conversation. So we talk over the phone. I get a general sense of what it is that you're looking to accomplish. General sense of those people that you're interested in naming as beneficiaries or naming as your agents under powers of attorney. Then I'll email you a questionnaire that you'll fill out. It gives me a lot more details, birth dates and spelling of names and things like that. And then we sit down and we go through, and I provide a whole lot of education because I want my clients to really understand what it is that they're doing. And to consider all the different aspects of that, right? Because we have to think about who do we want to take care of our children. Should it be this person? Should it be that person, right? Should it be a relative? Should it be a friend? Where are our relatives at? Maybe our relatives live in another country or live in another state. And so it's important to really have an in-depth, conversation about all of those issues so that when you plan, you know that you have things locked down exactly the way that you want them to be locked down, right? It's all about empowering you. And so as we do that, leading you through the conversation to consider these various issues is critically important. And so that's when, so once we go through that, then that's when I will quote you a fee, which is going to be based upon your particular needs and your particular issues and goals.
So what you're doing by this consultation and these emails, you're molding each estate planning to the individual, that because some people may have much less property and it's less complicated, but people more property and more assets become more complicated, but there's a lot more money at stake or investments at stake.
That's right. And other issues, right? So if your estate, again, is going to be subject to estate tax, then that is going to be really important to plan, because there are ways of minimizing that if we know about it at the beginning, right? And so that's why that in-depth conversation is so important, which is why my entire model for practice is all about creating that comfort and that intimacy, because that's the only way we're really going to get down to brass tacks about what it is that we want, what are our goals, and how do we make sure that we plan to meet those goals and meet those needs.
Great. We're winding down on time here. We hit major points with this estate planning issue. We answered a caller's question. There was another caller, he called in, but he didn't call in today, so I can't remember what his question was. That's okay. But if you have more questions, reach out to Eddie. Give me the website again.
Sure, firesideplanning.com. Bring
it up on the YouTube, please, and give your phone number while we're on the air here.
Yeah, so I'm going to give my cell number, 773-263-1185. And my email is @firesideplanning.com.
That's very easy, @firesideplanning.com.
That's it.
That's very easy to remember. Get a hold of Eddie if you have any questions. I'm going to move forward. I got a lot of questions I got to ask him. He brought some good key points today about jewelry and everything else, and I didn't think about prior to this. And it's not even in my existing will, my current will. So I have to make sure it's revised for me. You also mentioned you recommended, besides my book, The UI Jury Trial, you recommended another book. What was the other one?
That's right. Well, first off, I want to put that one up because you're talking about valuable books, and this is a super, super valuable book. When I was an assistant state's attorney and when I was a criminal defense attorney, having something like this would have been tremendously valuable because it really goes through everything that you need to know about trying a DUI case from both the defense perspective and the government perspective.
He's talking about my book, DUI Jury Trial, but go to the other book. What's that one called?
So the other one, this book is called Wear Clean Underwear, and it's by a woman named Allie Katz, who's an estate planning attorney. It is a choose-your-own-adventure book of what things can happen if you fail to plan appropriately, particularly with regards to minor children. So I'd recommend it to anyone. It's a quick read, but it really is very good at highlighting the potential problems with not planning.
My friend, we ran out of time. We're 10 seconds here. Eddie Olivieri at firesideplanning.com. Get a hold of him. The book is Wear Clean Underwear by Allie Katz. My book is DUI Jury Trial by William Pelarenos. Join us next week for another interesting conversation right here on Life Experiences on WRMN 1410 AM. Have a great week.